put an army there to make sure the law was followed. On the other hand, the colonists, England gave a lot of freedom to the colonists. They allowed them to establish their own government, to have their own courts, so long as the law of England was the law that was used in those courts. And so they were giving a lot of latitude. Now, each one of the colonies were separate and pretty much distanced from each other. There wasn't a lot of communication. It was almost like, you know, there were 13 different states. In fact, the matter is, the year before the Declaration of Independence, the Continental Congress that had been established to as a kind of a central governing body of the colonies at that time had gotten England to allow the colonies to be, their name from being called colonies to be called states. And so by 1775, these colonies were now called states. Now, the people of America, regardless of what colony they happened to live in, all paid taxes to England. And I've already said they were all regulated by the law of England, the English common law. And Parliament, of course, was over there in England, and they were imposing more and more taxes on America. And there was an undercurrent of not liking that, shall I make it simple, and opposing the kinds of taxation that was being imposed upon the people of here in America. Their main objection, of course, in addition to being taxed, was not being represented in the Parliament. And so a few people, let's call them a minority of people, began to rebel against the law of England and the country of England, the King of England. Now, of course, they couldn't travel 3,000 miles to fight a war against England, so the next best thing is they began to fight a war against the army that was occupying the country. By 1775, the Continental Congress, that, by the way, already we had about 9 presidents up until the time of the Declaration of Independence here in this country. None of them lasted much more than a year. Some of them just lasted just a few months. But the Continental Congress had already begun to work on a document called a Constitution. And so it was already in the framework of being developed, expecting that we would eventually and fairly soon, sooner the better, be free from the dominating control of the law of England and the army that was there to enforce it. So, by 1776, while that new Constitution hadn't been put into force yet because we were still a colony of England, the war was ongoing, and by 1776 in July, 57 men got together and wrote the Declaration of Independence. Now, those 57 men, most of them were wealthy. A lot of them were lawyers, judges, farmers, plantation owners. They all, they knew the risk of declaring independence from a country like England. And they all knew that they would probably die. And the fact of the matter is, within a year after serving that declaration upon the government of England, they all did die. A rather horrific death by the British Army, who went after each and every one of them. Not only did they die, but their families died, and they lost all of their properties. And so the consequence of being one of the founding members of our country by the Declaration of Independence was a very bad ending for them and their family. But they were willing to assume that risk for what they believed was right. The war started, and it was at first just skirmishes, as you can imagine. War during that time was just hand-to-hand combat. If you had a rifle, you had to see the eyes of your enemy, or you wouldn't be able to hit them with it. And it wasn't like you could stay 5 miles away and shoot a big cannon and expect to hit anything. And so it dragged on, but after the Declaration of Independence, it began to wane in the favor of the colonists in America. And the more the people began to accept it. Now, as I said before, the majority of the people didn't want to go to war against England. And even after the war was lodged, the majority of the people still didn't want to be at war with England. They were still loyal to the crown. And they recognized the risk, but the few that did are willing to jeopardize their lives did gain enough strength. And Washington, of course, was the commander of the Continental Army, and the war was raged on. It didn't end until the early 1780s by what is called the Treaty of Paris, when, for all intents and purposes, the Revolutionary War was ended. Well, after the Declaration of Independence, and it began to appear that America had won the war, the British Army, England had a lot of trouble sending over more troops because it took at least 30 days to come over here, and it was hard to reinforce them with not only able-bodied men, but also with food and supplies that they needed. So it wasn't so long after the 1776 period that, the war, for all intents and purposes, had ended, even though it took until, I think it was 1781, the signing of the Treaty of Paris that finally brought an end to the whole thing. Well, so now we have 13 states, all independent of each other. Nobody in charge other than the states themselves. Each state had its own legislature. Each state had its own set of courts. Each state had its own governor. They were as independent as the nations of Europe are. They fought a war to be independent, and they didn't want anybody else other than themselves, that is, the people of their state, having any control or rule over them. That worked pretty good psychologically, but it didn't work economically well at all. Because what happened in two aspects of the business life of each one of the states, they weren't able to do business with foreign countries, and they were having difficulty doing business with people in different states. The main reason each state had different laws. In other words, there was no uniformity. So the people in New York would have their laws, and the people down in North Carolina would have their laws, and it made it tough for them to be able to buy and sell goods and trade. It made it even tougher for them to buy and sell goods to England and to France and to Spain and some of the other foreign countries that they had business with. So, remember that I talked about they were putting together a constitution even before the Declaration of Independence? That process continued fairly quickly until the year, now I think I'm going to get back on here.
$1787?
No, I'm all mixed up in my notes here. You have to forgive me. You think after sitting here all morning, afternoon, or evening, I would have, well,
Yeah, 1787.
well, that's not, it was actually earlier than that. Well, the Articles of Confederation were first formally proposed by representatives of the 13 states in 1778. It took about 2 years for those Articles of Confederation, that new Constitution, and I don't want to miss something here for you. The very first Constitution of America was called the Articles of Confederation, not the Constitution as we know it today. Well, I'm going to do 5.
Okay.
In around 1778, representatives from each state came together trying to resolve some of the problems, especially in the areas of interstate commerce and foreign trade. And resulting in this meeting was a document called the Articles of Confederation. See where you write that in? The states, while very independent, recognized the need for some form of central government, but at the same time they wanted to make certain that the power and authority given to the central government would be very limited and would never become what they had just fought a war over. The states wanted to keep control and to be certain that the power to govern would remain with each state. The new form of central government that was established by the Articles of Confederation was called confederal. This new document established a confederation of independent states, but with a central government and even a Congress. However, it left the states still able to decide what matters the new Congress would regulate and control. The new central government was made to fail, mainly because it had no money and no way to get money. So just to try to summarize what we have here in this paragraph, these 3 or 4 paragraphs is that after the war, our states are independent, and they like being independent, except to begin to see that there were some problems in the area of business that they needed to get resolved, and the only way they knew how to resolve them is to have some form of central government that would control those things for them, and not leave it up to each one of the states. And so they sent representatives, and that, I think it was again about 1778, to create some kind of new central government. But remember, they just completed the war. In fact, the war wasn't even completed yet in many aspects. So why would they want to create a new central government when they just fought a war to get rid of a central government? So they needed it and they didn't need it. Okay, it was half a dozen one, 6 of the other. So they put together a central government that was very, very loose. It was just a confederation of the 13 states. The central government did not have any final say-so in anything. The states still maintained control. In the central government, it's Congress, and it had a president, decided that, a law was going to be such and such as it related to interstate commerce. If one state didn't like it, they didn't have to approve it. They could just trump it. The states maintain control. That's what confederal form of government basically means, is that the member states have the final word in whatever the central government create and makes. Also, you can see that in the document called the Articles of Confederation, the states weren't required to pay money to this new central government to support it. So if they didn't like it very well, they just stopped. They controlled the purse strings, and the central government just, lost its way because it couldn't support itself, and they didn't have the power to tax.
And that's why it did collapse, from what I read, is that a lot of states just refused to pay.
That's right. They didn't like what the central government was doing. They just refused to pay. So, 1787. A constitutional convention was called in Philadelphia for the purposes of amending, circle the word amending the Articles of Confederation. A serious problem had further developed in the area of interstate commerce and foreign trade. Interstate commerce and foreign trade because of conflicting state laws. Another important issue at that time was slavery. The northern states saw the convention as an opportunity to impose their will on the southern states and to try to abolish the practice that had been going on for several hundred years. When this issue was addressed at the convention, it so angered the southern states' representatives that they were ready to pull out and leave the convention with nothing being resolved. And as a result, it was agreed to leave the issue to another day. In 1864, the southern states left the Union and the Civil War began. Slavery was a practice even before America was established. But when America was established, it was basically established up in the north and down in the south. Up in the north, we had manufacturing, we had commerce that was selling its goods and wares over to England and France. And in the south, we had a more rural farm-like, and they raised the cotton, they raised the hemp, and they needed labor. It was very labor-intensive. And so the most common thing to do was to go to the West Indies and buy the African slaves that had been brought over from Africa by the slave traders to the West Indies, and the plantation owners bought those people and brought them here to America and used them as their slave labor. Now, the northern people didn't like that, and they tried as best they could to get the southern states to not do that kind of thing, but just because of being so independent from each other, the northern states were not going to do what southern states weren't going to do what the northern states wanted them to do, because they needed those people. They needed them for their farms and for their plantations. And so it wasn't resolved by the Constitutional Convention. By the way, you know what time of the year the Constitutional Convention was convened in Philadelphia? July. Have you ever been on the East Coast, or specifically to Pennsylvania or Philadelphia in July? It is hot and it is muggy. It's unbearable. Now remember too, they didn't have air conditioning. And so these men, and by the way, it was always men at that time, that gathered as representatives of the states. And by the way, there were only 9 states that sent representatives. The other 4 states did not, because they didn't see the need for it, because they wanted to maintain their independence. And so in a hot, muggy room with the windows down, because they didn't want to hear, they didn't want the crowd that was looking in through the windows to hear what was being said, because it was pretty contentious, as you could imagine it would be, especially when it came to the issue of slavery. Well, number 7. And instead of amending the Articles of Confederation as originally planned, the representatives at the convention in 1778 ended up writing a completely new and different document entitled the Constitution. This new document created a new form of central government called a federal form of central government. The Constitution became known as the supreme law of the land. The Supremacy Clause is found in Article 6 of the Constitution, and under this clause, state and local laws that directly conflict with the federal law are rendered invalid. Now, the federal form, number 8, the federal form of government is one in which the states form a union, and the sovereign power is divided between the central government, sometimes called the national government. We more refer to as the federal governments today. So they have the central power of government authority between the central government and the state government. They divide it up equally. This relationship is a partnership. When neither partner is superior to the other, except within those particular areas of exclusive power given to the central government by the Constitution. Initially, the specific powers or authority given to the central government had to do with interstate commerce, foreign trade, and the central military. As each state, it took about 2 years before the Constitution was finally ratified, even though it was basically written in that Constitutional Convention in 1787. As each state adopted it, they joined up to the Union. And by adopting the Constitution, they agreed to the terms and provisions that are written in the Constitution. Remember, a preamble and seven articles. In those articles of the Constitution, we find the three areas of life of America being given solely over to the central government: interstate commerce, foreign trade, and the central military. Once the states approved that, they no longer had the power to regulate anything of those three things. They no longer could trump the central government's decision-making on any of those three things. But those are the only three things that the states gave their power to the central government over. Nothing else. And that's true even up until today. It wasn't too long after the making of the Constitution that disputes began to arise between the central government and the states over new issues that had nothing to do with just the three that were initially given to them. Disputes like immigration and taxes and the like. And during the last few years, the central government has been asked to take on and make more laws on social issues like abortion, sexual behavior, and the like. Over the years, and the point of it is, while it's not in the Constitution, but over the years, the states have given over the power and the authority of other things to the federal government. Why do you think states have done that? Primarily because it was just too politically hot for them to make their own decision. It was all about politics. And so if the legislatures in a particular state didn't want to deal with a particular issue, they just allowed, kind of by osmosis, the federal government to step in and start making decisions in those things. And so today, which one do you think has more power and authority over you, the federal government or the state of California? Sure, I think we all think that, and in many ways it's true. Well, number 10, excuse me, the author of your textbook provide a whole chapter to the discussion of constitutional law. The material in the book is not intended to be exhaustive, but to only give you a brief look at the subject. The U.S. Constitution contains the preamble and 7 articles. The first 10 amendments, known as the Bill of Rights, were enacted and became effective in 1791. See, almost about 10 years after the making of acceptance of the Constitution. Thereafter, additional amendments have been enacted, and today there are a total of 27 amendments, with the most recent one being enacted in 1992. Once the representatives who had gathered in Pennsylvania back in 1787 decided to write a new document called the Constitution, they had in mind 2 very important concepts. The main purposes or goals when writing and establishing the Constitution were, and the most primary one, is to protect the people of the nation from the central/federal government. Primarily, the purpose behind their whole Constitution is to protect the people of the nation from the federal government. You see, again, we just fought a war to get rid of a 500-pound gorilla off our backs. And so any new document is going to be primarily for the purposes of keeping us from being involved in the same old stuff that we just fought a war over. Now, B, in less importance, in other words, the first one is primary, the second one would be secondary, is to establish the organization and the jurisdiction of the central government. Establish jurisdiction and the organization of the central government. Now, what is the The organization of the federal government? Do you know?
What organization?
The organization of the federal government that's set forth in the Constitution. It's made up of how many branches?
3 branches.
3 branches. And what are the names of the 3 branches of the federal government?
Executive branch,
Legislative.
Okay, one or the other. Executive branch, legislative branch, and the judicial branch. Okay? What's the main job of the legislative branch of the central government?
the laws, create laws.
To make laws. What's the main job of the executive branch?
Enforce laws,
To enforce what laws?
the laws that Congress created.
The laws that the legislative branch created. And what is the job of the judicial branch?
Interpret laws.
Interpret the laws. And what do they use to interpret the laws made by the legislative branch and to interpret the actions of the executive branch? What do they use to interpret that? The Constitution, the benchmark. In looking to see whether the legislation was constitutional, looking to see whether the action is constitutional. It's not uncommon that over the years, and in fact is it started fairly quickly, the conflicts. Oh, by the way, what do we call this 3-branch of government? What is it accomplish? What's its purpose? Checks and balances. And this idea of checks and balances is to check one against the other. Why not 4 branches of government? Why just 3?
Because it will be even. It'll always be-
Because it would be even. And there could be a split, right? 2 and 2. But with 3 branches, you get a fact is that they're not always gonna agree, are they? Do you see how the Constitution was written to make certain that the branches of the federal government don't get along and don't agree? Don't despair when you find out that the legislative branch of government isn't doing very much. Because the less it does, the better off we are. Really. The more the federal government makes laws that control you and me, the more we're controlled. And so the Constitution establishes a way of a government called a federal government to make certain that the legislative branch doesn't do too much. Now, you always get a problem when you got a Republican president and Republican legislature, because it looks like they're all gonna get cahoots and do too much together. And the same thing is true of being a Democrat. It really works well when you got a Democratic-controlled executive branch and a Republican-controlled legislative branch, because then they are conflicting all the time. Well, early on, it happened that there were conflicts, and so there was, let's just make up one here, legislative branch make a law, and the executive branch wouldn't enforce the law, so there was a conflict, okay? And so they were battling each other, and the question is, well, who's gonna resolve the conflict? Because believe it or not, there's nothing in the Constitution that tells the branches of government which one is gonna prevail if there's a conflict. Now, do you think it was by accident these men left it out? I don't think so. I think they just left it up for other people to decide that kind of thing, and here it is. 1803, the most important case in the history of our constitutional law, the case of Marbury, M-A-R-B-U-R-Y, Marbury versus Madison. Marbury versus Madison in 1803. The United States Supreme Court decided that it would be the one who makes the decision. When there's a conflict between the 2 branches of government, Marbury versus Madison in 1803, the Supreme Court made the decision.
Where are you reading this?
I'm not reading it now.
Oh.
I'm just kind of shooting from the hip now. Marbury versus Madison was the decision of the Supreme Court in 1803. that it would be the one who had the authority and only authority to resolve conflicts between the other branches of the government. And since that date, that decision stands firm. Nobody's challenged it. There's been no constitutional amendment, no even an attempt to change it. They leave it up to the Supreme Court to make that kind of decision. What do we call the first 10 amendments to the U.S. Constitution?
Bill of Rights.
The Bill of Rights. Now, again, it's interesting to note that in the Constitution that was initially created in Philadelphia, there are no Bill of Rights. There's nothing in there about the rights of any citizen as compared to the government. And the reason they were left out is the representatives knew that if they went back to their states, they wouldn't get it approved. And so it was agreed among the representatives at that particular time that we'll just leave it the way we have it, and we'll deal with the individual rights of citizens of our country as far as federal government is concerned at a later time. And it took them about 10 years for that later time to happen. And they amended the Constitution, and of course, each state had to approve of the amendments by a 3/4%. In other words, 9 out of the 13 had to approve of it. And they finally did, and we have the Bill of Rights. What amendment applied these guarantees that are found in the first 10 amendments, guaranteeing the rights of citizens as far as actions of the federal government only? What amendment to the Constitution also extended these same rights over as far as state versus citizens are concerned? It was almost 100 years later in the 14th Amendment, called the Equal Protection Clause, where the Equal Protection Clause in the 14th Amendment applies the 10 Bill of Rights to citizens of states against state governments also, as it did to federal government. Okay. Now, chapter 6, you have the handout material there. I'm going to read pretty much through this. Administrative agency law. Yes.
I just want to know, is Marbury versus Madison the case that established judicial review from the Supreme Court?
Well, in fact, that's what gave the power. They made the decision. They have the right to make a decision over conflicts of government. No, judicial review was established in the Constitution.
Okay. That gives the Supreme Court the right to interpret the Constitution, right?
In the Constitution. In the Constitution. Marbury versus Madison only decided that the Supreme Court would be the one who had the authority to resolve conflicts between other branches of government. There were only 2 other branches of government.